Hello, students. Welcome to lecture 5 of our Human Rights in India course. In this lecture, we'll explore two major ways of understanding human rights, the legal approach and the sociological approach. These perspectives go beyond the philosophical or historical theories we studied earlier and looked directly at how rights function in practice. The legal approach sees rights as creation of law. According to this view, rights exist only when they are recognized and enforced by the state. Courts, constitution, and legal systems give rights their real power. Without enforceability, of course, rights remain abstract. On the other hand, the sociological approach views rights as social products. Rights are not only about legal recognition, but also about how society understands duties, relationships, and collective welfare. Thinkers like Rousseau Pound and Leo Duguid argued that rights exist to serve social needs and must evolve with society. By studying these approaches together, we can see that rights are both legal claims and social realities. Laws may declare rights, but society shapes how they are used, respected, or sometimes ignored. This lecture will analyze both perspectives, show their strengths and weaknesses, and explore examples from India and the world. It will also discuss how combining legal and sociological perspectives gives us a more complete understanding of human rights. Our lecture today follows a clear agenda so that we can understand both approaches step by step. First, we'll explore the legal approach, its concept, key thinkers, and examples, and we'll see how law and the state make rights enforceable and binding. Second, we'll examine the sociological approach, its concept, main thinkers, and examples. This will show us how rights are shaped by society, duties, and collective welfare. Third, we'll discuss hybrid approaches, which combine legal and sociological perspectives. This section will highlight how courts and laws and social movements work together to expand rights. Fourth, we'll reflect on the strength and weaknesses of each approach. The legal approach provides enforceability but may ignore social realities, while the sociological approach is flexible but risks relativism. Fifth, we'll compare insights from India and the world, from Indian constitutional cases to global convention like the ICCPR and CEDAW. We'll see how law and society interact in shaping rights. Finally, we'll conclude with a summary and preview of the next lecture, which will look at Western and non-Western perspectives on human rights. This roadmap ensures we move systematically from theory to practice, combining legal clarity and sociological realism. The study of human rights require us to look at how rights operate in law and society. That is why we turn to the legal approach and the sociological approach. The legal approach focuses on the idea that rights are created and enforced by the state. Thinkers like Jeremy Bentham and John Austin believed that without law, there can be no rights. In their view, a right is meaningful only when backed by courts and legal remedies. The sociological approach, however, argues that rights come from society itself. Rights are not just texts in the constitution, but living practices by customs, duties, and social struggles. For example, labor rights, gender rights, environmental rights often emerge from social movements before becoming law. These two perspectives highlight an important contrast. Legal rights are about enforceability, while sociological rights are about social acceptance and evolution. Both are essential for a full understanding or a complete understanding of human rights. In India, we see a balance in practice. Fundamental rights provide legal guarantee, but movements such as Dalit struggles, women rights, and environmental rights or environmental activism show the sociological side. Thus, this lecture introduces a hybrid way of thinking. Law provides stability, while society ensures adaptability. Together, They make rights both enforceable and meaningful in everyday life. The legal approach sees rights as creations of law and sovereign authority. According to this perspective, rights exist only when recognized and enforced by the state. Thinkers supporting it are Jeremy Bentham, John Austin, and Hart. Bentham famously dismissed natural rights as nonsense upon still. He argued that without legal backing, so called natural rights are meaningless. Austin, a legal positivist, similarly stressed that rights depend on the sovereign command. Hart refined this idea by linking rights to legal system and enforceability. A central principle of the legal approach is ubi ius ibi remedium. Where there is a right, there must be a remedy. This means that unless rights are enforced through courts, they cannot truly exist. This approach emphasizes the authority of the state, clarity of the legal systems, and importance of enforceability. It focuses on rights as legal claims protected by remedies rather than moral or philosophical ideals. So, strength of this approach is, of course, practicability. It ensures that rights are not vague promises but enforceable protections. However, its weakness is that unjust laws may also be recognized as rights. If law alone defines rights, oppressive laws may pass as legitimate. Despite this limitation, legal approach provides the backbone of modern constitutional and international rights framework. The legal approach builds on a few central ideas. First, the state is central. Rights exist only because the state recognizes and enforces them. Second, rights exist only with enforceability. A legal right must be capable of protection by courts and remedies, otherwise, they remain paper tigers. Third, legal rights are always subject to restrictions and limitations. There are always reasonable restrictions, like freedom of speech can be limited by for reasons of security, public order, morality, etc. So legal system balances rights with responsibilities. Fourth, sorry courts interpret and expand the meaning of the rights. Judicial rulings often decide how rights apply in practice. Article 21 is the best example of the manner in which courts have expanded it from mere freedom from death and detention, or mere physical freedom, to right to live with dignity, right to speedy trial, free legal aid, dignified source of livelihood, quality life, life with dignity, freedom from sexual harassment at workplace, blah blah. It is all because of judicial activism or judicial reinterpretation of the existing rights. Fifthly, the legal approach provides clarity and structure. By codifying rights in laws, constitution, and treaties, it creates order and stability, and of course, clarity. Legal remedies ensure protection against violations, and citizens can appeal to courts when their rights are denied. And not only court, now we have many other mechanisms also which have legal sanctity or constitutional backing. Thus, legal approach ensures that rights are not just theories but real and foreseeable claims. Legal approach is reflected strongly in both international law and Indian constitution. At the global level, we have documents like UDHR, ICCPR, ICSCR, etc., etc. All show rights as legal commitments of states. In India, we have fundamental rights enshrined in constitution. We have landmarks of, Supreme Court cases that have expanded, defined, and redefined these rights under changing circumstances and changing needs. We have glaring examples like Keshwanand Bharati case that established the basic structure doctrine. Menka Gandhi case, 1978, that widened the scope of Article 21, making right to life and liberty much more expansive. Puttaswamy versus Union of India recognized right to privacy as a fundamental right. So these are the examples that show that legal approach provides a firm foundation for rights, and by codifying and enforcing rights, the law ensures stability and accountability. Legal approach has its own strengths and weaknesses. Like It provides clarity and stability. It ensures enforceability. It gives judiciary a strong role in protecting freedom, but there are weaknesses like laws can be unjust, they can be oppressive, and the oppressive laws may still count as rights. Social and economic barriers often prevent equal access to legal remedies. Poor or marginalized groups may find courts expensive and time consuming and thus inaccessible. Legal texts may fail in practice. For example, rights against caste discrimination exist in laws. Same with gender discrimination. It exists in law, but gender inequality continues to be practiced very frequently in the society. Thus, while the legal approach gives rights enforceability, it alone cannot guarantee justice. Without addressing social realities, rights may remain legal on paper but ineffective in daily life. Reflecting on the legal approach raises an important question: are legal rights alone enough to ensure justice? On one hand, legal approach is essential. It provides remedies, enforceability, and stability. Without legal backing, rights remain vague and unenforceable. On the other hand, legal rights often fail when they ignore social and moral justice. A law may recognize equality, but if society practices discrimination, the right remains ineffective. The Constitution tries to balance the two by combining fundamental rights with DPSP. This reflection shows that laws alone cannot guarantee justice, and right needs to be supported by social change, cultural acceptance, and moral responsibility. The sociological approach shifts focus from law to society. It argues that rights are not just legal creations but social products shaped by human relationships, duties, and collective needs. Key thinkers includes Pound, who saw law as a tool for social engineering designed to balance competing interests in society, and we have Leon. Uh, we have Leon Jaggi, who emphasized duties over rights, arguing that individuals must fulfill responsibilities for society to function fairly. Emily Durkheim, a sociologist, highlighted how social solidarity and collective morality shape rights and obligations. This approach stresses that rights are dynamic, not fixed. They evolve with changes in society, culture, and economy. Uh, Unlike the legal approach, which depends on state authority, the sociological approach highlights community and responsibility. Rights are seen as meaningful only when connected to duties and social welfare. The strength of this approach is its realism and adaptability. The weakness is that it risks relativism, justifying unjust traditions such as uh, caste practices, parda, unequal inheritance rights, and so many other practices in the name of patriarchy and culture. Nonetheless, the sociological approach or perspective reminds us that rights are not just words in law books, they are living realities shaped by social movement, social conditions, collective struggles, and evolving cultural values. So, sociological approach rests on several key ideas. First, rights are rooted in society, not merely in law. They reflect human relationships, community bonds, and social practices. Second, rights are connected with duties. Individual freedoms must be balanced with by responsibility towards other. For example, right to education also implies the duty to learn and contribute and disseminate the knowledge that we have earned positively to society. Rights are dynamic and evolving. They change as society changes. For instance, rights to digital privacy or environmental protection or the entire concept or notion of women empowerment. Fourth, rights emerge from social struggles. Movements for gender justice, workers' rights, and environmental protection demonstrates how society pushes for new rights which are later codified into law. Fifth, the approach stresses balance between individual and social good. Rights are not just about personal liberty, but also about community welfare. Finally, this sociological approach emphasizes adaptability. Unlike rigid legal frameworks, it allows rights to evolve with changing contexts, making them more relevant to real life. This approach, therefore, adds depth to our understanding by showing that rights are live practices. Sorry, the rights are live practices shaped by social reality, not just legal declarations. Sociological approach is visible in many examples, both in India and globally. In India, reservation policies for scheduled castes, scheduled tribes, and other backward classes show how rights are shaped by social context. These measures aim to correct historical injustices and provide equality in practice, not just on paper. Same is with the inheritance rights of women. Labor rights and workers' protections also reflect sociological thinking. Laws such as Minimum Wages Act and labor welfare schemes grew out of demand from social movements. Globally, the International Labour Organization ILO conventions reflect the sociological view that rights must address social and economic realities. Environmental rights provide another example. Movements like Chipko movement in India or global climate justice campaigns highlight that rights are connected to duties towards nature and community welfare. These examples show how society shapes rights before law formalizes them. They also provide that rights are not static but are dynamic and they respond to the changing needs, struggles, activism, and the new challenges in the society. Thus, sociological approach highlights the role of culture, activism, and community in shaping rights, complementing the legal framework. The sociological approach again has its own strengths and weaknesses. Strengths, it is realistic as it connects rights to social practices and struggles. It is flexible and adaptable, allowing rights to evolve with society. It emphasizes duties alongside rights, promoting balance and responsibility. It highlights the role of community and solidarity, not just individuals. But there are certain weaknesses also, like it risks relativism. If rights depend on only on social norms, unjust practices like caste discrimination, child marriages, parda, uh, uh, ban on widow remarriages, unequal property rights for women may be justified. It lacks universal standards. Excuse me. What one society sees as rights, another may deny, leading to inconsistency. It sometimes underplay the importance of legal enforceability, making rights vulnerable. Thus, while the sociological approach adds richness and realism, it must be balanced with universal principles and legal protections. Otherwise, it's risks justifying harmful tradition. There's a big debate going on between universal human rights and cultural relativism. This all has to do with this particular aspect of the rights. Reflecting on the sociological approach shows that rights are not limited to courtrooms or legal texts. They must be understood in real life, where social conditions and inequalities play a crucial role. For example, right to equality means little if caste discrimination continues in daily life. Similarly, the right to free speech is hollow if poverty and illiteracy prevent people from expressing themselves. Equal rights for women, equal property rights for women are also just paper tigers if people do not practice equality or they are not well versed in democratic values of equality. So sociological approach insists that rights must work in practice, not just in theory. Whatever is given by the constitution should be applicable on grounds, should be seen on the ground. This perspective is especially important in addressing new challenges. digital rights, migrant rights, and environmental rights are all shaped by social realities before they are recognized legally. The reflection here is that rights need both social acceptance and legal enforcement. Law may exist, but if society resists change, rights will remain ineffective. Conversely, strong social movements can push states to create new laws. Thus, the sociological approach reminds us that rights are living realities shaped by society and they must balance individual liberty with community welfare, adapting to cultural, economic, and technological changes. Today, we increasingly see hybrid approaches that blend legal and sociological perspectives. Rights are both legal claims and social realities, and neither approach is complete or enough or sufficient. At the international level, treaties like ICCPR, CEDAW, and CRC combine enforceable commitments with recognition of social change. In India, hybrid approaches are visible in judicial activism and public interest litigations. Courts often go beyond legal text to address social realities. For example, Article 21 has been expanded to include so many things: right to food, right to safe drinking water, livelihood, privacy, environmental rights, freedom from sexual harassment at workplace, freedom from torture in police custody, etc. etc. Movements for LGBTQ plus rights, LGBTQ plus rights, women's empowerment, and environmental justice also show how law and society work together. Social activism raises demands and courts or legislatures codify them into enforceable rights. Um, the Act on Sexual Protection of Women Against Sexual Harassment at Workplace is one of the best example of judicial activism. Till 2013, there was no such act at all, despite large number of working women in our country. And despite that in 1998, a country witnessed famous Vishakha case, wherein guidelines were issued by the Supreme Court to protect women against sexual harassment at workplace, to fill that gray area till the time a law is drafted. Though it took many, many years, but Supreme Court guidelines guided the various institutions to give enough protection to women. And moreover, judiciary has clubbed sexual harassment at workplace, protection of women against sexual harassment at workplace with Article 21, 14, and 16. That shows how the hybrid culture works. So, hybrid approach, therefore, you see that reflects the global local interplay in rights protection. They show that neither law nor society alone can ensure justice. Rights survive when both reinforce each other. When we reflect on both legal and sociological approaches, we see that each has unique strength and weaknesses. Legal approach provides clarity, structure, and enforceability. It ensures that rights are not just ideals, but binding obligations. However, it can be rigid and unjust laws may still exist. Sociological approach provides realism and adaptability. It connects rights with duties, activism, and social change. However, it risks relativism and lacks universal standards. Cut. हाँ ठीक ठीक The Indian Constitution reflects a blend of both. Fundamental rights provide legal enforceability, while directive principles reflect sociological goals of social justice. Judicial activism bridges the gap, making rights meaningful in practice. Globally, too, rights frameworks combine law with social recognition, as seen in international conventions and grassroots activism. The reflection here is that rights are strongest when law and society reinforce each other. Rights need the force of law, but also the acceptance and energy of society to become real in people's lives. PM Modi's slogan of Beti Padhao, Beti Bachao is the best example that we made sex based equality as a fundamental right way back in 1950 with the enforcement of the constitution. And we draft, there are a number of provisions in the constitution ensuring sex based equality as a fundamental right, equality in the matters of public employment, equality in education, equality in employment. But still we had to pass equal pay for equal work act in 1976, because despite law, society was not ready to accept working women. And even if they accepted women working, they were not ready, the society was not ready to pay them the same which they were paying to the male counterpart for the same work. Despite the fact that sex based equality is a fundamental right, India was witnessing large number of female feticides, and therefore we were facing sharp sex imbalance in sex ratios. And there were number of states where the number of females was extremely low, and therefore Prime Minister Modi in this 21st century was forced to give a call from Red Fort that Beti Bachao and Beti Padhao. So that shows that unless the society accepts the law, unless society accepts the rights as a legal claim, unless the society accepts the rights as rights for everyone, nobody can ensure the real exercise of these rights. To conclude, both the legal and sociological approaches are essential for understanding human rights. Legal approach, as said, ensures enforceability, clarity, and remedies through courts and laws. It gives rights, authority, and structure. The sociological approach adds depth and adaptability, showing that rights are shaped by society, duties, and activism. Examples from India and the world show the interplay of both constitutional guarantees, landmark judgments, social movements, and international treaties, sensitization movements all combine law with social practices. The key lesson is that rights are legal, social, and moral dimensions, and a healthy combination of all legal, social, and moral dimensions. Law makes them enforceable, society makes them real. Law will never become real unless it is accepted by the society, unless it is imbibed by the society. No law in the world can erase gender inequality unless the family, the father, the parents accept equality between the daughter and the son. So, laws makes them enforceable, but society makes them real, and morality gives them meaning. This integrated view prepares us to address contemporary challenges such as digital rights, environmental rights, social justice, women empowerment, empowerment of the historically subjugated classes like scheduled caste, scheduled tribe, and of course, minorities also in many, many countries. Rights are not static, they evolve with law and society together. In our next lecture, we will move beyond these approaches to explore Western and non Western perspectives on human rights, further broadening our understanding of how rights are conceived across cultures. Thank you.